Mr. Hermes?
Good morning. May it please the Court. I am Peter Hermes. With me is Adam Combies. We have the privilege of representing One Beacon Insurance Group and Cummings Properties in this matter. In March 2006, Dr. Schaefer executed a lease with Cummings for her office at an office park in Beverly, Massachusetts. In February of that lease required, among other things, that Dr. Schaefer buy insurance for the benefit of Cummings for claims arising out of her operations and her use of the premises rented by her. In February of 2007, Dr. Schaefer purchased insurance from the appellee Norfolk. Under that policy, for a premium of $10, Cummings was added as an additional insured. In July of 2007, Ellen Morrison claims to be injured in a slip and fall in a common area at the office park. She subsequently brought suit against not only Cummings alleging negligence, but also against Dr. Schaefer. Dr. Schaefer, who had purchased the insurance for the benefit of Cummings, notified her insurer. Cummings made demand upon Norfolk for insurance coverage, defense, and indemnity. Norfolk's response, notwithstanding adding Dr. Schaefer as an additional insured, notwithstanding having had the opportunity to review the lease and determine that the leased premises included by definition common areas under the lease, brought this action rather than to provide coverage. The decision of the Superior Court in granting summary judgment was based upon the erroneous determination that General Laws, Chapter 186, Section 15, which limits certain indemnity obligations of tenants in situations where the landlord is solely responsible. The court, Justice Feely, determined that that applied to a contractual undertaking to provide insurance by the tenant for the benefit of the landlord.
Now, would it matter if the lease had said that Dr. Schaefer's leased premises are solely her offices, but there's a separate provision that said we require you to insure all the common areas? Would that provision violate Section 15?
I do not believe that it would, because the effect of the insurance was not that Dr. Schaefer was giving indemnity. In fact, the effect was that Dr. Schaefer was procuring a benefit for Cummings from a third party, Norfolk. And under paragraph 17 of the lease, the only detriment to Dr. Schaefer was that if she didn't provide that insurance, she could be sued by Cummings for that insurance premium, in this case, a premium quantified at $10. Secondly, while there may be issues, and Your Honor had a case similar to this where the lease had a definition of leased premises which was very narrow, and the insurance policy had a narrow definition that said those leased premises.
But that case, as I recall, didn't include anything about this statute.
That case did not focus on, A, whether Section 15 applied to the insurance obligation, or B, whether there was any problem whatsoever with an insurance policy covering obligations of the additional insured where the named insured procuring the insurance was not negligent. The Macrogiannis case of this court in 2004, in a manufacturer-vendor situation, Justice Ireland, in his opinion, specifically held that a vendor buying coverage for the benefit of, or rather the manufacturer buying coverage for the benefit of the vendor, that coverage was not limited as a matter of law to an act arising out of the joint negligence, but could provide coverage for an additional insured even if there was no negligence of the party purchasing the insurance. So the answer to your question is yes, notwithstanding a narrower definition of leased premises, the insurance obligation, in the opinion of the appellants, is enforceable, Your Honor.
Okay, so what you're saying then is that we should interpret this statute simply to bar indemnification in which the tenant would have to pay, but not to bar indemnification in which the tenant's insurer would have to pay.
That is correct, Your Honor. The word insurer does not appear anywhere in Section 15. And in fact, it is instructive if the court looks to Chapter 149, Section 29C. It relates to indemnity in the context of subcontractors, general contractors, and owners. That statute, that was originally passed in 1984, prohibited both an indemnity agreement and insurance. The legislature knew how to prescribe insurance for the benefit of another party if it wished to do so. After a year, the legislature revised that statute, took out the insurance prohibition, and left only in there a limitation on indemnity.
What's that statute again?
It is Chapter 149, Section 29, uppercase C. So that in this circumstance, we have a statute that makes no reference to insurance. The only case law which makes reference to this statute and the insurance issue is the decision of Judge Keaton in the Pano case in the Federal District Court and the decision of Judge Fabricant in the Bergstresser case. In each of those cases, the judges deciding them determined that the insurance obligation was separate and different from the indemnity obligation, and
Now,
that
you
the
know the
obligation.
Superior Court judge says, well, I'm not persuaded by Keaton J., the expert on insurance, because it's in a footnote, right?
It's not a
Well,
footnote.
it's not in a footnote. No, what Judge Keaton said was that an argument was made in a footnote,
I mean,
and
the
then
argument,
Judge Keaton
yeah.
went on and discussed that argument in the body of his opinion. It was not a statement
No,
in
I
Judge.
understand that.
And this is an area where clearly Justice Feely thought differently than Judge Keaton and Judge Fabricant. What I suggest, Your Honor, is that he got caught up in the notion that because he felt that Dr. Schaefer could never be responsible for the accident that had occurred, because it was on a common area, that therefore there couldn't be this concomitant insurance responsibility. He was wrong for two reasons. Number one, the standard in Massachusetts is if a tenant has sufficient knowledge concerning a condition, it may have a duty toward its invitees or one of her patients with respect to a condition on common areas. We don't know the answer to that question because Justice Murtaugh in the Superior Court stayed further proceedings in the underlying case pending this court's action. So as the case stands today in the Superior Court, Ms. Morrison has alleged negligence by both the tenant, Dr. Schaefer, and the owner, Cummings, but we don't have an answer as to how that comes out.
Now,
I
this-
mean, how do you mean you don't have an answer as to how that comes out? Because it wasn't she way on the other. I mean, what's the
The status of that case today is it has been pleaded that Dr. Schaefer does have responsibility, and no court has been made a determination that she does not.
And were there facts supporting the claim of negligence by the doctor, or just
The only indication in the record is the complaint in the underlying action and a letter by plaintiff's counsel in the underlying action that makes some hearsay statements concerning how the accident may have occurred. But because there is no determination, first of all, it's irrelevant how that comes out. This court has determined that regardless of the absence of negligence by Dr. Schaefer, that there can be situations where insurance can be provided. That's number one. Number two is the statute doesn't direct itself towards insurance. There is an easy way to say that. You can say, we do, that a covenant to insure or name as an insured is void and unenforceable. That's what happened in Section 29C before it was repealed, before the insurance provision was taken out. That did not happen here. The statute is in Chapter 186. It reflects upon the relative responsibilities of landlord and tenants.
But if the purpose of the statute was to prevent a situation in which a landlord has no incentive to avoid negligent conduct or negligent conditions, why would we view insurance, which has the same consequence, different from identification?
Well, it's hardly the case that the landlord has no incentive to take care of its premises because, in fact, the landlord cannot get indemnity from its tenants with respect to its own negligence. That is the effect of that statute. And secondly, if the landlord had...
But they can get insurance. I mean, if you basically say require the tenants to insure all the common areas so that the tenant is paying all the insurance, and if the landlord's negligent, the tenants will have higher premiums, Where is the incentive for the landlord to avoid being negligent?
A landlord wants, when it's leasing to tenants, a high-quality property that people want to come into. If it has a property where people suffer injuries, where it is shabby, where all sorts of untoward and unhappy things occur, no one wants to rent there.
And if the legislature had
fact-
that confidence, why would they have passed this statute? I mean, if they were so confident in the care in which landlords took care of their premises, why bother to pass this statute?
Because what the legislature did not want to do was to visit the consequences of landlords' negligence on tenants. It was not speaking to the issue of insurance. And in fact, as Norfolk and Dedham admits, that covenants for insurance in leases are regularly enforced. This is the economic climate in which all of us as tenants live. The Superior Court rents space in a Cummings building in Woburn. I rent space in a building. I walk through common areas. The incentive for tenants to be careful is that they are bringing people into the building. If the landlord simply had purchased insurance and passed on the premium to the tenant as part of the rent, we would have no discussion here. But what would happen is that it is likely the landlord's insurance would be rated at the rates for the most risky tenants. If you had an actuary who had no customers, he basically walked to his office, he had a small suite, he picked up the phone, he spoke to people, he sent out his reports and analyses. The charging him the rate of, for instance, the doctor, not Dr. Schaefer, but the doctor who is a gerontologist, who has septuagenarians and octogenarians coming into his or her office, where the risk of a slip and fall is correspondingly greater, there is a difference in risk. So the passing of the insurance cost on allows the tenants who have different risks to bear a more reasonable cost as it relates to the operations that they conduct on the premises.
Certainly, Section 16, is it 16 or 15? 16?
Well, the statute is Section 15, paragraph 16 of the lease.
Yeah, surely, just because the landlord is solely responsible doesn't mean the landlord can't buy insurance, right?
In fact, the landlord did buy insurance that is excess, in effect, excess over that bought by the tenants. So the landlord does say, in fact, in the event, the landlord buys or says to the tenants, buy certain limits. The landlord buys limits over and above that, so it does incur an insurance cost. It has an interest in keeping its premiums down by taking due care with respect to its
And
premises.
as you say, there's nothing in this statute that would prohibit the landlord from buying all of the insurance, all the liability insurance for all of the entire property, and then allocating the cost to the tenants, right?
That is correct.
No problem.
In fact, that argument has, I mean, the practice in the rental industry, as indicated by the briefs submitted by the various amici, suggests that it's an everyday practice. Standard leases require the purchase of insurance.
And indeed, indemnification is not the same as purchasing insurance.
Well, in this case, it is very graphic. Dr. Schaefer will never be responsible for any judgment against Cummings. Either Cummings will be responsible, and it has the benefit of insurance purchased at a cost of $10.
By the tenant and also by Cummings, because
Yes.
depending on the level of responsibility.
That
and
is correct.
Damages.
Or, in the alternative, Dr. Schaefer may be responsible because she's adjudicated to be negligent in this case, although in certain circumstances you could imagine that possibility being more remote than others. But certainly, if Dr. Schaefer knew of a risk in a common area,
It failed to alert her customers to avoid that area. There might be some liability. There might be a duty.
and this court in its cases has pointed to the existence of that type of potential responsibility on the part of a tenant. But the obligation of the tenant to perform in a non-negligent way as it relates to his or her duties to invitees or other on the property is divorced in analytical terms from the existence or not of an insurance obligation and the risk of the insurance obligation. Norfolk and Dedham had the opportunity, had it chosen to do so, to look at this lease and determine the breadth of the definition of leased premises and to modify its additional insured endorsement if it wished to do so. I suggest that in the case decided by Justice Gantz in the Superior Court, he referred to a much narrower provision, insurance provision. This is a broader provision. It talks about ongoing operations or premises rented to you. When you look to the lease, Norfolk and Dedham could have said, my gosh, this is problematic. We don't want to insure this. It did not do so, or it did do so and rated the risk at $10. Either way, first of all, the claim falls within the coverage of the insurance, and the insurance admittedly was issued pursuant to a
It falls
provision
within the coverage of the insurance because?
because it arises both out of Dr. Schaefer's operations,
Right.
and it arises on premises rented to her, premises being defined in the lease by paragraph 16 to include common areas.
So if it wasn't a patient of Dr. Schaefer, this policy wouldn't apply. Is that correct?
I'm not certain that that is the case.
Well, if this was a customer of some other
No,
tenant.
in fact, Your Honor, you were correct, because the lease provision speaks of the breadth of that obligation relating to the tenant's operation, so that is correct. That's why the insurance is limited. It is not every person. If the patient of the dentist came on the premises and slipped and fell, there would not be an obligation on that part. I would request that the court reverse the entry of summary judgment, enter an order directing that the Superior Court declare that the insurance obligation exists, that there's a duty to defend and indemnify Cummings, and that Norfolk and Dedham has the obligation to reimburse One Beacon for the defense costs it has incurred in defending Cummings to date. Thank you.
Thank you, Mr. Hermes. Mr. Feeney?
Thank you, Your Honor. Robert Feeney for Norfolk and Dedham. Your Honor, I'm here with Attorney Jenny Tibbetts. I'd respectfully submit that the judge in the trial court was correct, that 18615 was intended by the legislature to place upon the landlord primarily the obligation, whether on an out-of-pocket basis.
The obligation to buy insurance?
I'm sorry?
I mean, you agree that the landlord could have bought the insurance for the entire complex
I sure
and
do, Your
assess the tenants the cost of that.
I certainly do, Your Honor.
Not a problem.
Not a problem. And the reason that I believe that 18615 was contemplated by the legislature to include insurance obligations, not just indemnification, is twofold. First, this court made clear in the Evans case that the promise to purchase insurance is an obligation to indemnify. This court has said in the past that they are one and
But
the
it's
same.
not the lessee, it's not the lessor's promise to indemnify the lessee. Right?
Correct, Your Honor.
So the lessor here hasn't promised to indemnify the lessee.
Of course not.
Right. There's insurance, which is the indemnification vehicle for whatever limits on the policy, right?
Well, the insurance provision in this case is not triggered in any event, and I'll address that issue if the court wishes now. What I would prefer to do, though, is answer the issue raised by counsel, and that is his construction of this lease provision as placing on the tenant the obligation to insure. I'd respectfully submit that while that construction works well for Cummings and it works well for large national insurance companies, it doesn't work for tenants, it doesn't work for persons injured on commercial properties, and it certainly does not work for courts, which must adjudicate claims of folks that are injured on those properties.
If we agree,
and the reason,
if we agree with you, aren't we sort of confusing indemnity with insurance?
I don't believe so, Your Honor. Respectfully, I'd submit that in the context of 18615, they mean one and the same, and here's why. If we accept Cummings' construction, that all of the many tenants on this large commercial complex with many buildings is obligated to get insurance indemnifying the landlord, no matter where the accident occurs on the tenant on the property, no matter how it occurs, whether it's on the common areas for which Cummings agrees, it and it alone is solely responsible or not. If that's the construction,
Well, wait a second. That's not the construct. We're talking about an injury that occurs in the course of the tenant's business. This is a customer of the tenant.
I disagree, Your Honor. I don't believe.
She's not a customer of the tenant?
She's a customer of the doctor, but as the term has been construed by other cases, I'd submit that the indemnification provision is not triggered because it cannot be said that this accident arose out of the ongoing operations or the use of the leased premises. I'd submit that
Well, the ongoing operations, this is a doctor's office. So you've
Yes,
got
sir.
patients that come in, they park in the parking lot. The common area, the leased premises, includes areas, parts of the common area used by the tenant's customers.
Of course.
Okay, so I'm missing the point here. Why isn't that precisely on point?
Well, because arising out of has a meaning in the Commonwealth of Massachusetts. Under Riccitelli or other cases, it's been held that it's not quite proximate cause, but it's not but-for causation either. Under 14929C, the other indemnification statute that counsel referenced, in the Miley case, a new standard was enunciated. That was fact-based indemnification. And there, the court said that there has to be some action or inaction on the part of the party with the obligation to indemnify, which was the cause. That cannot be said here, because here, counsel agrees that the landlord had the sole obligation to maintain the common areas. Now, my point was going to be, Your Honor.
Mr. Feeney,
what-
isn't that a secondary analysis? I mean, don't we have to get, I mean, we get down to that ultimately.
It certainly is, Your Honor.
Okay.
And thank you for allowing me to back up, because the point I'd like to make is this. If we accept counsel's construction of this lease obligation, every tenant has to go out and buy duplicative insurance covering the same common areas. If we have a situation where, unlike in this case, Ms. Morrison had visited 5 of the tenants rather than just 1. Let's say we had a trip and fall claimant who was clutching 5 bags from 5 different stores at the Rentham Mall or some other outdoor mall. Under counsel's construction, the landlord would be able to look to all 5 to indemnify it. I'd suggest that that's an unworkable and an absurd result.
But you haven't claimed unconscionability. You simply have claimed it's in violation of the statute.
I've claimed that it's a violation of the statute, Your Honor, and I would respectfully submit that because it's an unworkable result for the courts and for the litigants, because it would substantially increase the work related to the most simple, straightforward trip and fall cases, that even if this court's not convinced that the statute applies, and I believe it should find that the statute does apply, I'd submit that the court should find as a matter of public policy that the use of the phrase leased premises when it does not convey the right to occupy is without any meaning and should be stricken as a matter of public policy. It should not be given effect because it's an unworkable standard. The other issue here is this.
So you're saying quite separately from Section 15, we should find that the definition of leased premises here is void as a matter of policy?
I am saying that, Your Honor.
In the lease?
Yes, unless it conveys the right to occupy. And I say that because I believe it's a completely unworkable standard. It turns on it really is a sea change for the insurance industry because, as is clear here, this was a mechanical routine endorsement for which Dr. Schaefer paid $10. It was never contemplated by Dr. Schaefer. It was never her reasonable expectation that
customers injured in the parking lot might be covered by her liability policy?
I don't
coming
believe,
to her store?
I don't believe, respectfully, Your Honor, I don't believe for a second that Dr. Schaefer could reasonably conclude that for $10.
Well, what about the insurance company who's looking at this? They couldn't have assessed this and said, well, you've got customers going in and out, or they might get hurt in the parking lot. I mean, this is all part of the standard risk.
Well, Your Honor, contrary to counsel's representation a few moments ago, I'm not aware of any Massachusetts case which extends a tenant's obligation beyond the area pertinent to the leased premises. That's true of the Woolworth case.
Don't we have a problem with that? I mean, this is appurtenant to the building. It's not appurtenant to her offices, but I mean, many of these big office buildings have a big common parking lot. Some of it's in front, some is at the back. So this, I mean, we would have to change appurtenant, wouldn't we?
I don't believe so, Your Honor.
Okay.
I believe that appurtenant generally means those portions of the premises adjacent to or dedicated to the use of the leased premises. That surely cannot be said to be the case here, where this accident happened on the complete opposite side of the building from where our doctor's office is located.
If I can turn the question that I asked Mr. Hermes around to you.
Yes.
Let's assume here that the leased premises was solely her medical office.
Yes.
And let's assume, are you saying that it would be void under Section 15 to say that the landlord, or that the tenant must purchase insurance to protect the landlord against any claim that may occur of landlord negligence on those premises?
I'm not saying that at all, Your Honor.
Okay, so, but if you're not saying that, I've looked at Section 15.
Yes.
It doesn't speak about common areas. It speaks about, it seems as if you would have to argue that in order to contend that the current insurance policy is void, because Section 15 says that a provision is against public policy and void if the effect of which is to indemnify the landlord or hold the landlord harmless to any other person for any injury, loss, damage, or liability arising from any omission, negligence, or misconduct of the landlord on or about the leases or the leased premises. So it includes the leased premises. So under your interpretation, it would be void to have a provision which says that the tenant is obligated to insure the landlord against somebody tripping in the hallway of your medical office and claiming the landlord was negligent.
I respectfully submit, Your Honor, the difference is this. Under a case like Your Honor proposes, and that was the very issue that this Court decided in Humphrey versus Byron, of course. In that case, it's not a situation where by any combination of words the lessor is attempting to shift liability for his negligence or other misconduct, because simply there's no duty in the Humphrey versus Byron situation. There, basically it's similar to a conveyance in real property rather than a lease. I'm giving you all of the obligations, the right to occupy the entire parcel, and with that, you take on the duty to insure and or you bear the financial burden for any injuries. I don't think that runs the foul of the statute at all, because since the conveyance itself gives the control and maintenance obligations to the party occupying that entire premises, it cannot be said that it's an attempt to shift negligence or other misconduct, because the duty to maintain goes to the tenant in that case. That's not the case here. My doctor, unlike the case that Your Honor proposes, she couldn't have even posted a sign in the common area on the other side of the building, assuming she was aware of some defect. She has no right to post signs. She surely has no right to make any changes or alterations to the structure. Here it's a curb at issue. She can't affect the outcome in this case, and therefore I'd respectfully submit Judge Feely was correct that she cannot be said to be negligent in this case. He was correct about that. And the other issue that...
But that doesn't necessarily help, because you still have a duty to defend in order to get to your motion for summary judgment. So are you saying the judge must make a finding of negligence to determine who is obliged to defend the action?
I'm saying, Your Honor, if this Court agrees with Judge Feely or affirms his decision that 186.15 applies, the analysis is negligence. On the other hand, Your Honor...
Are you saying that we must therefore find before the Court has ruled that there was no negligence on the part of the tenant, even though that matter is still being adjudicated in the Superior Court?
Yes, Your Honor. And it's not uncommon at all in declaratory judgment actions. In fact, many of the cases suggest that it's appropriate to make that determination at the earliest opportunity. Here, it doesn't matter what discovery we conduct. All we need to do is look at the lease and see where the allocation of the maintenance responsibilities are.
Mr. Feeney, could I ask you this? Forgive me for interrupting you, but I'm looking at Judge Feely's decision.
Yes,
and on page 10, which is tabbed at C in the Cummings brief, he says the court rules that Section 17 of the lease is void under GLC 186, Section 15, to the extent it imposes insurance and indemnification obligations on Schaefer.
Yes, Your Honor.
Indemnification I can understand, but isn't Judge Feely doing the very thing that is causing some concern here, which is not distinguishing between indemnification and insurance?
Your Honor, for the purposes of the application of this statute, I'd
Right.
respectfully submit that Judge Feely was correct that they are one and the same.
Well, then why doesn't he say, to the extent that it seeks to impose indemnification obligations, and I conclude that requiring them to get insurance is in effect indemnification? That, by the way, would be quite an unusual conclusion, that indemnification and insurance is the same. I mean, for all kinds of other reasons, correct?
Well, Your Honor, I'm not so sure that it would. While I understand that the legislature excised certain language from 149C.
No, but just out there in the world,
Yes, Your
there's a real difference between indemnification and insurance.
I'd respectfully submit that there's not in practice. As a defense counsel who does a substantial amount of work for self-insureds and insured clients, when I get a letter demanding indemnification from a co-defendant, I don't pick the telephone up and call my client and tell him that they're looking for indemnification. I call the insurer, because I think even 149C, as the Hanoi's case points out, it's understood that the statutory scheme, as much as anything else, lets us know what insurance we should put in place. So even though a lot of the 149C cases talk about the duty to indemnify, it's understood, I think, and often it's stated outright, that what they're really talking about is which insurer is going to bear the burden. And in that vein, under 149C, there is no case which states that a general contractor can require a subcontractor to indemnify where it's the sole negligence of the general contractor that caused the accident. And that's what we have going on here. I respectfully submit that by analogy and by the plain language of 18615, this provision is barred as a matter of public policy. The other issue, again, as I pointed out earlier, is the reasonable expectation of Dr. Schaefer. It was suggested here that there was a windfall to Norfolk and Dedham because they got a $10 premium for the additional insured. I'd submit the real windfall is the premium in the tens of thousands of dollars that went to One Beacon. I'd ask you to affirm Judge Feely's decision. Thank you, Your Honor.
Thank you, Mr. Feeney.